Good afternoon, ladies and gentlemen. Welcome to BW Legal World's Saturday Solution segment, where we speak with experts on hot legal topics and latest legal developments. And today, on the occasion of Gandhi Jayanti, we have put together a very fitting discussion on the must-know legal rights when caught in the crosshairs of various law enforcement agencies in India, namely the Enforcement Directorate, Serious Fraud Investigation Office, CBI, local police, Economic Offences Bureau, and others. To make this happen, we're joined by Dr. Manoj Kumar, founder and managing partner, Hammurabi and Solomon Partners. Dr. Kumar is also the vice president of Society of Indian Law Firms, vice chairman of the Society of Construction Law UK India, and vice chair of the Natural Resources Committee of the Inter-Pacific Bar Association. Dr. Kumar is a recipient of the prestigious Mahatma Gandhi Samman awarded at the House of Lords, London. He's also an expert on the Inclusive Policy Lab of UNESCO, a visiting fellow at the Observer Research Foundation, a visiting professor at the IIM, and an editorial board member of Thinkers 50 India and independent director on corporate boards. Welcome, Dr. Kumar. We have with us Ms. Pallavi Pratap, AOR, and managing partner Pratap & Co. She has over a decade of experience and regularly appears before the Honorable Supreme Court, High Courts, National Company Law Tribunals, Consumer Commissions, NGT, and various arbitration forums. She is an MBA in Finance from La Trobe University, Australia, and brings with her unique understanding of corporate law and mergers and acquisitions, being former investment banker. She has been actively involved in cases pertaining to company law, IBC, white collar crimes, criminal matters, so on and so forth. We also have with us Mr. Sharik J. Riaz, Counsel UKCA and partner. Sharik is an alumni of Newcastle University, UK, and has been at the forefront of the firm's practice of white collar crimes. In his stint, he has represented several high profile clients of the firm before the PMLA Tribunal and its appellate forum, and also represented clients of the firm in criminal trials pertaining to Prevention of Money Laundering Act. So once again, a very warm welcome to all of our experts. Thank you so much for joining us today. I am Asha Maori, the managing editor of BW Legal World, who has the honor of moderating this august session. So experts, let's dive right into the conversation. And to begin this, let me put some, context to this. Understanding that corporate criminal liability as a legal concept is still evolving. We still haven't reached the levels to have very clear laws and clarity as to how we go about it. And given the multiplicity of agencies, for instance, we don't have a central agency investigating an offense that leads to a problem of over prosecution. We have what we might call a presumption of guilt. A single accused of a single transaction is first taken into custody by the ED, then the CBI, then the SFIO, and the train goes on. So this brings me to the question, that what are your thoughts on the whole landscape that we see today? Is there a neglect of the rights of an accused in our criminal justice system? What are the structural issues and how can one fight them? And today we're putting more focus on the economic offenses. So, over to you, Dr. Kumar, to begin with your thoughts, please.
Thank you, Ashima, for a very generous introduction. And of course, this is a very relevant topic to discuss, particularly on Gandhi Jayanti. In fact, last 2 years, we have been tossing with the issue of police reforms, and we've made submissions to the Home Ministry on what needs to be done to balance the scales between the rights of the accused and the rights of the law enforcement agencies, stroke the police. So therefore, when you want to talk about the landscape, I would want to step back a bit and talk about how traditionally our entire architecture around law enforcement has been conceived and implemented over the last century or so. Not much has happened in independent India in terms of thinking and speed work to bring the law enforcement process up to speed with the changed dynamics of business and the way business and day-to-day activities are conducted. We still have the legacy of the British and largely the police structure that the British gave us. Number of times this has been brought about. For some reason, because of this being an issue of the states and the center both need to align to bring about the reforms. Not much has happened over the last 7 odd decades. Finally, the Supreme Court stepped in about a decade ago and made very strong recommendations and then made it binding on states to carry out these reforms. So much of what we see today in terms of police complaint authority and the similar structures which have come about is pursuant to the Supreme Court intervention. And that too, as we speak, only a handful of states have done it. Now coming to the corporate, the economic offenses part. Unfortunately, the approach of lawmakers has been to each of the issues on a very ad hoc basis. While you mark an activity a crime in an economic sphere, you don't realize the difference between an individual committing a crime under IPC and possibly what could constitute a crime in a corporate transaction. Because it's a string of people involved, and therefore, where is the gray line? Where does it go wrong? What constitutes a crime? What nuances are there with respect to evidence, collection of evidence, with respect to rights? Because there's no clear accused in a corporate crime. Of course, the law enforcement agencies want to map all the way to the board of directors in most cases. Whereas something could have been committed at a very different level altogether. Principles of officers' liability, stroke criminal liability is something being tossed around in the Companies Act quite a bit. We are aware of it. We are now seeing strings of criminal liability coming into the company law as well. The officer in default liability principle is also being diluted, and therefore the board is now liable for most compliances. And a compliance report, we are all aware the 2013 changes that have come. Now the board is directly exposed. The board cannot take a certificate from an officer and just say that, we have done our duty. They're exposed directly, and therefore they're exposed to the criminal liabilities as well. So my take is that, as much as we want to have a level playing field in the business and corporate area between the different stakeholders, we cannot just apply the existing criminal jurisprudence which we are carrying from the British time with respect to the police working on the corporate corporate crimes or white collar crimes as we see. We need a far more refined and balanced approach where the rights of all the stakeholders are protected, and rights of people don't fall within the gap of the lawmaking that should have kept pace till now. So that's all from me for now, and I can always contribute.
Thank you so much, Dr. Kumar, for setting the context and that. Over to you, Pallavi. Quite many right gaps in the system. What are your thoughts?
I think Dr. Kumar has actually spoken so well about most of it that I really do not have too much to address as far as corporate crime is concerned. However, there are quite a few areas that we see specifically since it is Gandhi Jayanti. We've been noticing that there are legal rights which are not provided to the citizens at all. I mean, the recent case being the Gorakhpur case that a lot of us would have read in the newspaper. And like Dr. Kumar said, that, police reforms, I think that is a complete, misnomer in that sense to look at the Gorakhpur case which happened. And the manner in which it is being handled just now, I think there is volumes that requires to be spoken about. I agree with Sir with respect to Prakash Singh case that it was definitely when Justice Kehar and everybody intervened and said that, there is a requirement that, the state governments should come and the Home Secretary especially should come and put it on the affidavit that these are the steps that they're going to do in terms of, having appropriate police personnel, police training should be provided, etc. But this was more to do with, IPC related offenses. When we saw PMLA and specifically how it evolved, I think Sir obviously would have seen it to a much larger extent when this act actually came in 2002. And then you see that it comes in effect from 2005. Major amendments actually only took place in 2009 and 2013. And that's when I would say that it became draconian in that sense. where you've got attachments of properties which are being done left, right, and center, and there's no, the adjudicating authority is not working. There is no appellate authority just now. Everybody has to go in a jurisdiction to the High Court if there is an appeal that needs to be done. Thankfully, a lot of it is being addressed before Justice Khanwilkar's bench just now in Supreme Court, where specifically most of these problems of PMLA are going to be addressed. We also saw Justice Nariman, who, in Nikesh Tarachand, he gave, I think, one of the most brilliant judgments to put in a lot of PMLA-related problems that were put into rest. But when we see, specifically around Section 50 or so, where we see that, the director has been given the power of acting as a civil court and to be able to, have anybody summoned and without even addressing, any of the statements which are there, not even a fair trial in that sense, like you would have in 161, for instance. You would have a statement which is recorded before, the investigating officer. But then you can only use that statement to confront a witness. But here, any statement that is getting recorded before the director is actually going to be used against you. So the entire principle of natural justice, it's just not there. And this is why I feel PMLA, in some senses, as a matter of fact, I don't think I will be actually misquoting myself here, but a lot of provisions were taken up from UAPA and put into PMLA, which is where we see that, if UAPA was supposed to look into terrorism, this was only supposed to look into money laundering. But connecting the two is where we are finding a lot of problems, and especially in terms of effectively having it run through, at least in the country. So the intention was completely right. I mean, I think money laundering, of course, continues to be one of the biggest problems that we face, especially when you link it with NDPS matters and things like that. But essentially, I think there is so much which is wrong with the act that it causes definite, those one would have imagined that those were the teething trouble which comes with, new acts. So for instance, when IBC came in, there were these teething troubles that everybody had. But PMLA has been there for such a long time that these teething troubles should have been done away with by now. We are seeing, like Sir said, when there is any ECIR which is registered, you will have the CFO, the directors, the CEO, the CTO, everybody will be, sitting in front of the director, and they will not be getting a bail at all. If this is how we are trying to run our corporate sector, then I think it is definitely difficult for them to survive in the country, current state. So I think that's about it from me. I hope to hear more from Sharik now.
Yes, thank you so much, Pallavi. Over to you, Sharik. Do you also agree that there is too much of an interference of one legislation into another? And what is it that we are seeing today?
Yeah. No, after having heard Mr. Kumar and Pallavi, I think they've broadly covered. Actually, they've broadly covered the main aspects of the act which cause problem as far as the regular citizens are concerned. But I think I just want to address the fundamental problem, which is the architecture of the act. If you look at the act, PMLA, let's take PMLA for example, the definitions are overbroad. They can literally bring in everyone under the sun. In fact, the recent amendment of 2019 made it even more over. What was overbroad was made even more overbroad. You used words like directly, indirectly, doing money laundering. When you use these overbroad definitions, then any activity can be brought within the dragnet of money laundering. In fact, now as we speak, any imprudence, any negligence, which is not criminal per se, can be brought within the dragnet of PMLA. So what the act has done, it has compounded the problem. And I mean, Pallavi said that the intention was right. I agree with her on that aspect. But the implementation, the execution has been absolutely wrong. I do not see any convictions happening under PMLA. I do not see the attachments being taken to the logical end. All the attachments are being done in a mechanical manner. Like Pallavi pointed out, the tribunals are not working. Fortunately, in March, we had the judgment of the Punjab and Haryana High Court, which clarified the law and said that the properties acquired prior to the commission of the offense cannot be attached. Before that, anything that you had acquired way back in say 80s or 90s or even inherited property was liable to be attached. And unfortunately, under the scheme of the act, you have the burden is on you under section 24. How do you discharge that burden? Well, property which is accrued to you by operation of law, by law of inheritance, is now up for grabs, and they attach everything. And the tribunals, as a matter of course, they confirm all the attachments. The appellate tribunal till Justice Manmohan was there was some hope. But after Justice Manmohan left, I feel, I mean, that's my personal experience of it. At least he had the judicial acumen to at least distinguish between what is a mechanical attachment and what is an attachment which actually deserves to be confirmed. But now it's all become mechanical. And now even the tribunal not functioning, we have to run to the high courts, get a stay from there. And most of the time the officers do not even record their satisfaction. There is no satisfaction to begin with. The act says that you have to satisfy yourself that the property is liable to be transferred or concealed, and based on that apprehension you then have to attach. But you simply pick up the words of the act, do you reproduce them in the attachment order, and say that they're likely to be concealed and transferred without even giving an iota of evidence to that effect, that as to how and why a property which has been acquired in 1990s is now likely to be transferred. And especially even for residential houses in which people are living, you've said they are likely to be transferred, and then you've attached them. And the attachment content, and this happens ad nauseum for I mean, in all of the cases I've seen, attachments have happened. It's a serious cause of concern, and even the scheme of the act is such that the moment the attachment gets confirmed by the adjudicating authority, you have to vacate within a period of 90 days. You have to hand over possession. So you're actually running against time when you're trying to kind of save the home and hearth on which you're living. So the architecture of the acts have to be looked into. There are various aspects, like Pallavi talked about section 50. I just had a case just yesterday. A person who's already charge sheeted in a PMLA is now being called upon to record statement under 50. And I say it's a violation of my constitutional right. I have a right to remain silent. You can't now compel me to give an evidence. It might be an innocuous statement, but the law is that I cannot be compelled to give evidence whatsoever once I am an accused. And that's a constitutional right. No statutory right can prevail over that. But this is what is happening. They call any and everyone, and everyone has to go. Even people say in Bombay have to go to Delhi to record statements. I mean, in for that matter, any other state in which the offense has taken place. And the overbroad definitions, the usage, the mechanical application, I think this is all the anathema of the system that we are currently dealing with. And bail, one example. Fortunately, like Pallavi just said, Justice Nariman's judgment, it struck down the twin conditions. But now they are seeking to revive it again. And the trial will take 5, 7, 10 odd years, and the person will languish in jail. I mean, his rights under 21 are, all caution is thrown to the wind just because you believe some guy has gotten money and he's laundered it, and you have absolutely no proof of that. And now with the definitions, even it's directly or indirectly, you can be brought in, and you might as well suffer incarceration for long years, and there will be no bail for you. I mean, all of this are issues that have to be addressed. And I completely agree with Dr. Kumar and Pallavi that these things ought to have been decided by now. But we are still taking these baby steps. We're still giving this leeway to the investigative agency, when the law is, I mean, it's a cliched law, but I am innocent till I am proven guilty. All my rights are attached to me till the time you convict me. Before conviction, I have all the rights under the sun. Everything, the act may be in their favor, but the judges have to be in my favor. That's how I see it. But unfortunately, we get, they come up with these, terms like financial terrorism and money laundering and scams. And, I mean, at the end of the day, a judge is also a person who's living in a society. I mean, he does not want to be a person who somehow perpetuates the problem. So they're always, a bail is looked at, a nice stopgap arrangement to somehow stop everything. But unfortunately, it impinges on my rights. So I mean, all of this have been are issues which we have to look into, and the courts have to have a more than proactive role, not just a proactive role, a more than proactive role. And it's not a favor, it's their duty. It's their duty to preserve my rights. The courts are not doing me a favor by protecting me. They have to do it. Whatever be the scope, intent of the law, eventually the interpretation is up to the courts. So now the legislature has done what it has to do. But now I think the ball is in the court's hand. You have to come up with these progressive judgments which somehow expound the law, keeping it with sync with my constitutional rights. And the moment there is any transgression, you have to come down hammer and tongs on them. That, I believe, is what we have to look into. The courts have looked into, and we as lawyers have to somehow do our bit in evolving that jurisprudence.
Thank you, Sharik. Thank you so much. So clearly, constitutional rights are at stake. Dr. Kumar, coming back to you, to know from you, the idea behind today's webinar is to let the common man know कि what is it that they can do? वो क्या कर सकते हैं ऐसा जब we as lawyers are struggling, are here to comment on the law and how it's not being executed and implemented well. But imagine the plight of people who don't even understand the law. Now, in that scenario, what are the cases you've seen in your experience, spanning from small to big corporates or other people? What have been the various problems in those cases? And through that, what is the message you can send to the common person listening in today? ऐसा क्या वो अपने आप को safeguard करने के लिए कर सकते हैं? उनका ऐसा क्या first step होना चाहिए? Like Sharik mentioned, they have a right to stay silent. Now we need to highlight some of these rights for them. Over to you.
Yes, that was a very emotional and full of anguish, views from Sharik, and I completely share where he's coming from as a lawyer. Having said that, I think, of course, the menu for today is brush with law enforcement, so I want to restrict there. And just to mention, I think we have complete 100% faith in the judiciary. Justice Manmohan are, of course, a class apart, but I'm sure there are enough and more of Justice Narimans and Justice Manmohans. It's a matter of time when the right case goes before the right bench and you get the right judgment, which kind of brings relief, much needed relief, as we were discussing. Having said that, from my past experience, जो मेरा तजुर्बा रहा है अभी तक, before getting into specific instances, एक जो बहुत निचोड़ वाली बात यदि मैं बता पाऊँ, तो 3-4 चीजें हैं जो बड़ा इंपॉर्टेंट है अपने ध्यान में रखना. जब भी आपका अचानक से कभी किसी लॉ एनफोर्समेंट एजेंसी से ब्रश हो जाता है, या खासकर वी हैव हर्ड स्टोरीज ऑफ पीपल जंपिंग आउटसाइड ईडीज विंडो एंड सीबीआईज विंडो एंड किलिंग देमसेल्व्स, कमिंग अंडर प्रेशर, वो सब यदि अवॉइड करना है, हरासमेंट को कम करना है, तो 3-4 चीजें बड़ी इंपॉर्टेंट है. सबसे पहले तो कि यदि आपको अंदेशा है, इफ यू आर एक्सपेक्टिंग दैट यू आर लाइकली टू हैव अ ब्रश विथ लॉ, प्लीज गेट अ लॉयर ऑन योर साइड. डोंट वेट फॉर द ब्रश टू हैपन. इट्स वेरी वेरी क्रिटिकल, बिकॉज आप एक इन्फॉर्म्ड क्लाइंट के रूप में जो आप कंडक्ट कर सकते हैं अपने आप को, और एक अनइन्फॉर्म्ड क्लाइंट के रूप में, दोनों में बहुत अंतर हो जाता है. शायद इसीलिए किसी केसेस में खिड़की से कूदने की जरूरत पड़ जाती है. एंड व्हेन आई से इन्फॉर्म्ड, ऑफ कोर्स यू आर वेल इन्फॉर्म्ड अबाउट द फैक्ट्स, but informed from the legal strategy perspective, from the law perspective, कि आपकी rights क्या हैं, उनकी क्या limitations हैं, उनकी क्या rights हैं, वो क्या कर सकते हैं, कहाँ पे आप किस stage पे कौन सा relief आप ले सकते हैं. इसके लिए you should have a lawyer with you. That's number one. Number two, have your strategy in place well in advance. When I say strategy, essentially it involves analyzing the facts and evidence from your perspective, because you don't know, you can never have a 100% handle on what the law enforcement agency is likely to collect and put forward. So getting a handle on the relevant facts and evidence, getting a handle on your rights, जैसे अभी पीएमएलए की बात हो रही है, इसमें राइट्स का डेफिनेशन कुछ और होगा एक्यूज्ड का, जनरल आईपीसी में कुछ और होगा, कंपनीज एक्ट की वायलेशन होगी तो कुछ और होगा, अकाउंटिंग वायलेशन है या कुछ और है, एबीसीडी यूएपीए है, तो डिपेंडिंग ऑन वेयर एंड व्हाट इज द स्पेक्ट्रम ऑफ द फैक्ट्स दैट यू टॉकिंग अबाउट, गेटिंग अ प्रॉपर हैंडल ऑन योर राइट्स generally under the law, rights as an accused in the general frame which you can also be entitled to. And The other aspect is the possible remedies that you can have. What remedies for what, at what stage. बहुत सारे आप कभी डिस्कशन करेंगे वकील से तो वो 10 चीजें गिना देंगे आपको कि जी हम रिट में भी जा सकते हैं, हम बेल के लिए भी फाइल कर सकते हैं, हम यहाँ भी जा सकते हैं, उनके सुपीरियर ऑफिसर को कंप्लेन भी कर सकते हैं, हम वहाँ. सो amongst this whole spectrum of confusing remedies that you have, you need to really have a good analysis and a handle on what remedies, when, and what's the right time for it. ये सारी चीजें पहले होमवर्क कर लेने से बहुत कुछ आपका काम आसान हो जाएगा. और ये तजुर्बे से कह रहा हूँ बिकॉज हमने इस तरह के सपोर्ट दिए हैं. वी हैव सीन क्लाइंट्स कमिंग आउट ऑफ वेरी डिफिकल्ट सिचुएशंस.
Dr. Kumar, just to add one question there, such great points. How much reaction time does one get? When you want to engage a lawyer, आपको एक lawyer को engage करना है, उसके लिए आपको suppose this is notice issued, कितना टाइम मिलता है लोगों को ये सब करने के लिए?
यदि हम कॉर्पोरेट इंडिया की बात कर रहे हैं जिस पे मैं रेफर कर रहा था, आई थिंक उसमें आपके पास सारा टाइम है. इट्स लाइक इट्स सेड दैट वंस यू ग्रो बियॉन्ड say 35 or 40 you should do an annual health checkup, right? अपनी ताकि आपकी तबीयत ठीक रहे और आप अचानक से कोई हार्ट अटैक ना आ जाए, कोई शुगर आपकी. ये तो आई थिंक सपोर्ट, लीगल सपोर्ट ऑन अ कंप्लीट, वी कॉल इट राइट टू ऑपरेट. जो प्रोडक्ट हम ऑफर करते हैं एज अ फर्म, मतलब राइट टू ऑपरेट मीन्स दैट योर एबिलिटी टू ऑपरेट विदाउट एनी हिंड्रेंस. And when just a comparison of the age of 40 for a human being, I would say any business of a certain turnover and size, essentially where the risk exposure starts to increase. जब तक आप छोटे हैं, एक स्टार्टअप हैं, एक छोटे डोमेन में है, लालाजी कंपनी है. लालाजी is just a way to identify a one-man company. It's nothing to do with a certain part of our community. So as long as the setup is that your exposures are also different in a way. The maximum the exposure is to exactly what you do. But the moment you start growing in size, your risk all around you kind of multiplies in ways. And that too, you have more and more people doing work which have legal consequences. So it completely goes out of your control. And then suddenly you have a board, you have an independent director, set of directors, and then half the world telling the independent directors to behave as independent directors, you expecting them to behave as independent directors nominated by you. So they're trying to balance. Then the audit committee process and this process, that you get listed, you have SEBI suddenly, you have every investor organization running after you. So it's so on and so forth, and then of course your rivals and your competitors. और एक चीज बहुत इंपॉर्टेंट है कॉर्पोरेट क्राइम्स या इस तरह के व्हाइट कॉलर क्राइम्स में, इनवेरिएबली most of these cases are motivated. 90% are motivated. They are triggered by somebody who is out there to harass you. 10% are genuine, and in those 10%, it's very important to be sure, because there you are at the receiving end. But all of this 100% can be handled very well. जैसा आशिमा आपने बोला कि कब पता चलेगा, coming back to that, we just kind of strayed away somewhere. आप ठीक से अपने आप को कंडक्ट करेंगे बिजनेस को, एंड कॉर्पोरेट गवर्नेंस इंक्लूड्स लीगल गवर्नेंस, प्रॉपर लीगल काउंसिल थ्रू एंड थ्रू, तो वेरी हाई चांसेस आर दैट यू विल गेट एन इंक्लिंग कि ये कुछ आने वाला है. Because your risk factors get highlighted year on year, quarter on quarter, 6 months on 6 months. So whether you have that oversight with a good internal legal team or an external is your choice. All depends is what is the quality of the oversight. If you have very excellent in-house team which has the relevant and required level of legal acumen to be able to foresee into the things to develop, very good. Otherwise, go for external support as well. So that should kind of reduce the risk. Baki -1%, somebody just picking up a file against you with nothing in the file, just showing you the green color of the file and putting you into jail. That can happen. That's harassment. And there the law will take care of you. The courts will take care of you.
So thank you for that sound advice, Dr. Kumar. And coming back to the cases that you were mentioning, where I interjected.
Yes, as lawyers, we tend to, get into a discussion and it goes on. From proper, of course, there are many instances to take, but I just want to give one or two. एक particular वाकया ऐसा था हमारा कि one of our clients, no names, of course, because of confidentiality reasons, but one of our clients, they decided to set up a new plant and basically enter into a new business. The peculiar circumstances were that that business was a monopoly of a listed company in India. So there was only one company in the whole of India, which, for example, was supplying all the pipes that were being put into the drainage all over India. So you can imagine the kind of monopoly they had. And so anybody who wants to become a second player and start participating in tenders at all municipal and state and central levels is a challenge. And that's a straight hit on the top line and bottom line both. So there was a business rivalry, and something like 18 or 19 forums were fought altogether. Coming to law enforcement agencies, one of the law enforcement agencies there which were involved in the process were the local police of where this business house was, and the state CID and the crime branch. So these three put together had orchestrated a very unique process of harassing our client at all levels. Of course, setting up cases for the management to get scared of, and also harassing the employees, kind of, I won't get into very specifics, but they're basically harassing the employees. So at a broad strategy level, what would one do? One did everything that we talked about, the 482s and this and that, and we went to here and there, try to get each of these criminal legal processes dismissed. But at some point, we realized that no, the animal is much bigger than we foresee. So we came up with a strategy that will bring the entire administration of that particular state, the criminal administration, under investigation. Now, that was something very unique. Had never happened in the past. There was no jurisprudence around it. There was a string in Bhajan Lal's judgment, which we could pick up from here, but there's no instance like that. So we filed a writ petition in West Bengal, and the court was completely shocked. What kind of relief are you asking that, the state following three departments or the wings of the law enforcement agencies should conduct in a very transparent and accountable and not play into the hands, very, very, very broad prayers. How do you enforce the prayers? Of course, we were there and we said that, these are the circumstances. The fact is that we are being harassed. We can explain it. We can show it. We did show it to the bench. So with respect to enforceability, let's keep it for another day. We'll see when the court gives the order, how do we enforce it, whether we enforce it through contempt or there's compliance. But for now, we want you to issue notice and come and explain. And sure enough, the court did issue notice. And the magic was that the moment this entire set of law enforcement agencies came into the oversight of the court, because you had a pending writ where everything they did from then on could be reported and explained to the court. The conduct completely changed, and that was the turning point in this entire rivalry, where the law enforcement agencies were being used as a handle. And so oversight this is something, a learning that we developed, that the moment if you can't control the animal, go a level higher, just put the lights on, let everybody see how the animal behaves. So that's very important. At some points, it's not the usual medicine to be applied everywhere, but in some very difficult times when you're pushed to the corner, when your back is to the wall, I think the way to fight back is to completely take it open, expose it, and then therefore that's one. Another example quickly before my other colleagues can also come in. Similar brush with respect to a very big business house in India and a foreign company from Europe, and the whole effort of the big Indian business house was to throw this foreign company out of India. Essentially to ensure that they're not able to do business in India. And all instrumentalities of law enforcement were being used as a handle, right from ED to CBI to police, of course. And very unique things had to be done. For example, the ED would always pick the weakest manager in the team of our client. He would just not speak to the directors. He would just not speak to the lawyers. Their team would just call up this guy and ask him to come to their office in Bombay. And it went on similarly. The police would call up exactly the foreign directors. When they would come for a board meeting, they would receive a call that we want you to come to a certain police station. Very similar approaches, where something different that is done here is in most of these law enforcement initiatives which are backed by motivated action, facts have to be brought on record. Facts have to be brought on record so much that the law enforcement agencies come to a point that they have to explain what they do actually. So their ability to harass is much higher having one side of motivated facts, and gets reduced much lower when a whole bundle of facts are transparently put before the agencies. So we got a chance in this process, just to summarize, where somehow one of the string of these proceedings came to a magistrate. We made an application, because it was a very innocuous application. We knew that it will get rejected, but the objective was something else. We filed a section 200 application, which my colleagues would follow. In a 156 of the other side, we filed a 200 saying convert it to 200, let them lead evidence. These are the facts. And therefore, under these facts, this is completely motivated. The learned judge rejected our 200 vehemently, that you just have no locus, complaint is theirs, everything is fine, very well. But it took all the facts we had placed on record and used those facts to reject their 156. So strategy becomes very important. And similar approaches were done at ED and a few other agencies. We brought the ED under High Court scanner. There was proceedings in High Court, we brought the ED's conduct there. So a short point is that strategy plays a very long, a very, very big role in kind of handling your brush with law enforcement agencies. And therefore, advanced preparation is something that can always prevent a situation where you're taken by surprise, you're suddenly picked up, your house is raided, you're not prepared for the raid, you don't know what is an inspection memo, you don't know what is a detention memo, and you don't know the difference between the two, which is for your body, which is for your rights and property. And therefore, when they come, you don't know what questions to ask, what documents to verify. Advanced preparation goes a very long way, particularly in with respect to brush of law enforcement agencies with the corporate world. I hope these are some instances. There are many more, but I'll stop here so that my colleagues can take over. Yeah.
Thank you so much, Dr. Kumar. So many great inputs there, transparency, oversight, and such amazing strategies deployed. So thank you so much for sharing that with us. I'll move to Pallavi. And Pallavi, your thoughts on, you mentioned in your opening comments, PMLA being a very draconian law. Now, what makes it so draconian? And then, following it up with what are the rights therein for people to escape these draconian laws or their brush with PMLA authorities?
Considering that it is a draconian law, there are very few rights which are basically available. But like Dr. Kumar said, when Sharik had just finished it, he said, he's got all emotional. Now it's my turn to become all emotional about what all is wrong with PMLA just now. I think a lot of problems that are coming right now with PMLA is, of course, with the predicate offenses which are there. So earlier, when you had just Schedule A, now you've got Schedule A and B, everything has come over. The predicate offense, the whole terminology has become really vast in that sense. I think from a practitioner's point of view, there are a couple of things that I'd really like to pinpoint just now. And also the fact that these are matters which are pending before various high courts. So if somebody is actually going through, any of the practitioners who's going through these challenges, they can definitely, look at these proceedings which are just now sub judice. So for instance, Sharik had said about provisional attachment orders. So when a provisional attachment order is passed, there is a notice that comes and you have to provide relied upon documents, which essentially the ED does not provide. And there's a case which is going on just now before Justice Pratibha Singh. It's the Hamilton House case. So if the practitioners are there, they can actually take note of it. And there she's laying down the entire scope with respect to when and how the relied upon documents should be provided when the notice is sent. That is one. Second case which is going on just now is, I'm talking about Delhi High Court because that's the area where I practice more. The other case which is going on is just before Justice Rekha Palli, which is with respect to, and a lot of, I think Sharik and both Dr. Kumar will agree with me, that with the lockdown which took place, the adjudicating authority just now, the PMLA-AA, is has only one single person who's a technical member who's acting as a chairperson just now. Now, I'm sure Sharik and both Dr. Kumar, who would have addressed him in other provisional attachment orders, would know how he gives you only 5 minutes to argue an entire case, which is, I think, clearly against the principles of natural justice again. But having said that, there is a provision that within 180 days, if the adjudication has not taken place on the provisional attachment order, he becomes functus officio, right? So the AA cannot really, any order that comes out of it cannot be enforced as far as attachment is concerned, and therefore the property is not attached anymore, if we read the words of the Act. So there is a case which is going on, which is a Vikas WPA case, which is just now going on before the High Court. The single bench said that if 180 days have lapsed, even by 1 day, he becomes functus officio. So therefore, the provisional attachment order is redundant. That does not have any enforceability. Now, ED, of course, has gone in an appeal and it's lying before the DB just now. But I am hopeful that the 180 days clause would be read in toto, and that, that at least that particular part will be, adjudicated in light of the section. Because if there is a statutory provision, you really cannot overrule it just by, saying that, okay, there was a lockdown. If there was a lockdown, a lot of reliance has been placed on what the Supreme Court came up with, which was a suo motu, limitation-related order, which was there. But when you read that order, you realize that it was applicable on arbitration-related matters or maybe intellectual property-related matters, but they are not. That limitation does not really apply on the PMLA-related matters, and that's how the High Court has interpreted it. So this is the second part that I wanted to speak about because I thought the practitioners would benefit from it. Then the third one that I think, and all of these will travel to the Supreme Court, so I'm sure that we have another couple of years for the law to actually get settled down as far as these two are concerned. The third one, which basically encompasses all of these issues just now, is pending before Justice Khanwilkar. It's a special bench which is only looking at all of these PMLA matters, right from reasons to believe, which Sharik had pointed out initially. Now, this reasons to believe has been, I think, the biggest challenge any one of us actually has come across. These reasons are never given. They are bound to give you reasons to believe in writing. These are superfluous reasons which are given. Most of the times you won't even find those reasons which are given. When the attachment is happening, the reasons are never even given to you. So you don't really know what it is that you're arguing upon or what are the reasons which are cited. What the learned AA had held was that, those reasons are actually given in the notice. Those, and I doubt that Sharik would have ever come across, because I've never in any of my notices ever come across those reasons to believe. There are these simpliciter lines which are placed, which is subject to interpretation by anybody. So I think one of the major challenges that we are facing just now is with respect to Section 5 and Section 8, which encompasses reasons to believe. Now here, there is a judgment which was by Justice Muralidharan from Delhi High Court, where he had defined reasons to believe in an income tax matter. And there he had also, spoken about the PMLA reasons to believe. And he had said that, a reason to believe cannot be considered as, it does not give you an unlimited power to attach anything or to prosecute anyone. So I think those, specific parts of PMLA which are still subject to adjudication are these case laws, I think, are going to really define the entire landscape. And probably Sharik and I would not get so emotional about PMLA after that. That's one. Second, I think, yes, with respect to, like Sir said, the strategy part of it, I completely agree with him how he said that you have to have a strategy in place. Specifically because when you have a PMLA matter which is going on, it is never a PMLA matter. There are at least, this entire bouquet of cases which come to you from different other investigating agencies as well. And SFIO, needless to say, definitely gets involved in some manner or the other. And the interesting part is that, like Sir said, you have to be prepared with all the documents that you feel can go against you. And I have seen with one of my clients that we prepared everything, but when SFIO actually started investigation, it was a different level of forensic audit in that sense that they had done, which was very difficult for any one of us to foresee. Because, so for instance, my client was a CFO of an organization which was running for a long time. So for him to have that kind of an, understanding of what was happening previously was very difficult to gather. So, these things, I think the strategy is very important. It's just that, every time that our client was joining investigation, we were making sure that some sort of an anticipatory bail or some kind of an arrangement was made. However, what has always been a problem is, and especially when you are looking at ED matters or you're looking at CBI matters, because a lot of investigation which is happening with CBI is you don't really get to have your FIR. Especially in ED, you never get your ECIR beforehand, right? You will be called. Let's say, for instance, in a typical criminal case, what will happen is that an FIR will be registered. Most of these FIRs are now available online, so you can actually download it. And then you can have that strategy that, okay, I'll go for an anticipatory bail, and then probably I'll join the investigation if at all I'm summoned. Now, when it comes to ED, the ECIR is never given to you. So you don't know if you can actually go and apply for, any protection from arrest, and which typically does not really come through also. So once you've joined the investigation, then you are inside, you are in the judicial custody for a very long period of time. And I think that is where we've been seeing a lot of problems which are coming, because these are people who are, one of the biggest corporate names that we see. They've made their way up to, let's say, a CFO status or a CTO status or any of these, big corporate identities. They've made their way onto that level. And when they are asked to, sit in the police station for a very long period of time, one, of course, their reputation goes down. Second, their personal properties are getting attached. So, for instance, a property, like Sharik said, that, before the commission of crime, that property is getting attached. And, you are able, so the attachment is happening beforehand only. You are able to only prove it after the attachment is done. So if you read section 5, it says attachment, adjudication, confiscation, right? Whereas it should have, if at all, if you look at how the criminal law landscape is, it should have been adjudication first and then attachment should have followed. How is it that you can have the attachment first and adjudication? So I think, when you read the statute, you realize that sometimes, like Sharik pointed out, the intention is definitely right, but the implementation is definitely, there's a lot that requires to be done in this case. So yeah, I think I'll stop my emotional rant just now.
Thank you so much. No, absolutely. It's a topic and the occasion is such that we must bring out the flaws in the legislation or the system. I also wanted to touch upon plea bargaining and other aspects that seem to be missing in the system. But let me call in Sharik first. And Sharik, can you throw some light on the various problems with the ED and the issue of jurisdiction that comes up time and again? Over to you.
Yeah. So as far as the ED and the PMLA is concerned, I think what everyone, and I'm sure practitioners already know that ED does not have original jurisdiction to investigate, so to say. I mean, the investigation of all criminal offences, they vest with the police, and police is a state subject. I mean, we have another argument on the federal structure of our constitution on that, but I'll not go into that right now. But the role of ED comes in only after a predicate offence or a scheduled offence under the schedule of the PMLA is committed. And not just that, the scheduled offence must result into generation of proceeds of crime, and the proceeds of crime should then be laundered and then projected as untainted. So if you look at the scheme of the act, it's actually there are a few prerequisites for the ED to step in. Now, what the ED invariably does is that moment any of the scheduled offences are committed, which is for, I mean, which under the IPC are almost all the major offences which a person is charged with. So the moment any of the scheduled offences are committed, and if you want to somehow rope in ED to attain a collateral purpose, it's not really difficult for them to come in. They just see the FIR, they just see the scheduled offences there, and they barge in, and they raid and give you summons and whatever. Now that is where you have to identify, and to dovetail what Mr. Kumar said, you have to strategize. That's very important. So the moment you get to know that the ED is actually investigating a matter, you first have to take stock of the situation, whether based on a prima facie study of the case, does ED has jurisdiction at all? Because most of the times what I have seen is that they do not have jurisdiction. They somehow assume jurisdiction without satisfying the prerequisites of law. I'll give you an example. I'm doing a case, again, political overtones. I'll not name the parties, but the question of law is actually very interesting. So the charge sheet has been filed by the CBI. It's a cricket association matter, and the offences that have been charged are 406, 409, and 120B. Now, 406 and 409 are not scheduled offences. 120B is a scheduled offence. Now, we argued before the court, and unsuccessfully at the first instance, that how can the conspiracy to commit a non-scheduled offence become a scheduled offence? Because if 406 and 409 are not scheduled offences, then the conspiracy, by the same logic, I mean, it's a sequitur of that argument that if the main offence is not a scheduled offence, the conspiracy to commit that offence cannot be a scheduled offence. The matter came up before the single judge, and unfortunately for us, Karnataka High Court in that Congress leader D.K. Shivkumar's matter, it was a similar issue. 120B read with Income Tax Act, some section of the Income Tax, and they assumed jurisdiction. They argued this point that 120B does not clothe you with the power to investigate. It's a conspiracy. You have to have a scheduled offence. But the single judge there had ruled against us. And the ED relied on that judgment, and we made vehement arguments on this aspect that it defies logic. It defies logic. I mean, you are just trying to achieve something indirectly, what you could not do directly. But fortunately, that the judgment of the Karnataka High Court was sealed in the SLP and just landed before Justice Nariman. And Justice Nariman passed an order that no coercive measures be taken place. And the issue is still pending before the Supreme Court. And like Pallavi told, I think that's also been clubbed along before Justice Khanwilkar. It's one of those issues as to how what is the scope of the scheduled offences and whether 120B alone can bring someone within the mischief of Money Laundering Act. So the jurisdiction, analyzing the facts, strategizing, and if you realize that jurisdiction is not made out, I believe, I mean, that's the kind of practice I have. I take my chances in challenging the whole process, because I know it's once they set out on a wild goose chase, they will, I mean, like I just mentioned before, any imprudence, any negligence, they give it the color of a criminal misconduct, which unfortunately is not what the law intends. If I've done something out of my own negligence, if I've been imprudent, that does not necessarily give the transaction or that act the necessary color of being a criminal offense, so to say. So that is why I always try in the matters that I am doing to somehow nip the problem in the bud. And I only do it once I realize that, okay, fine, this is an arguable case. I'll take my chances, knowing fully well, of course, that the system is, the judges are not so keen in, stopping an investigation, because that's how it has been. They always want the investigation to go, and then after it culminates into a complaint, like it does in case of an offense under PMLA, then perhaps at that stage they want to interfere. But I always look at jurisdiction as the most important aspect when a ED matter hits my table. I first want to see whether jurisdiction is made up, whether there is actually some generation of proceeds of crime, whether those proceeds of crime generate out of the scheduled offense of which he is charged. Because at times they don't even look at that. They don't even see that whether this activity has resulted in this money. if you look at the original, the parent of this money laundering act that you have in India, it's the UN model act on money laundering, and because we're following that regime. Now, the act, the UN law or the UN model law was supposed to target certain activities, which were, like Pallavi and Dr. Kumar also mentioned, were of a different dimension altogether. Not every theft, robbery, everything in which there's money is involved, you somehow bring and trigger PMLA. Unfortunately, that is lost. We've not looked into that, and for once you read the act, the intent always is the last thing that the courts looks into. You always go by the literal interpretation of the act, and you see, okay, fine, the scheduled offense is there, the money is generated, so we have to yield to the investigating agency. But I try my best to somehow always look at the jurisdiction aspect of it and take my chances. Most of the times you're not successful, but it's worth the try. And I mean, it also helps in developing this jurisdiction. Like I just mentioned, that we have to have judgments, progressive judgments in sync with our constitutional rights. They will only come about once you take that initiative of taking a matter to court. Now, what happens when a client is served with a summon by the ED? Everyone is scared into submission. That is where the role of a lawyer comes in. You have to somehow lift that your client out of that fear psychosis which happens in his mind the moment he realizes that he is up against an investigative agency which has the blessings of the state. And if it's a matter which has political overtones, they generally, people are very, the last thing that they want to do is somehow take it heads on, which I always try to do. Whatever matters I have done, I always listen, now that this come upon us, now you either catch the bull by the horns or let it ram through a china shop. The choice is yours. So, I mean, sometimes the people they actually gather that kind of courage to actually take it up, but most of them do not. They said, okay, fine, we just want to do, we want to play safe, want to, whatever they want, we'll give them, not realizing that actually it's not their job to investigate all of this. If at all there is a criminal misconduct, it's an entirely different investigation. The police will look into it. It's a state subject. Let the state authorities look into it. The ED, made under the charter of a UN treaty, having a law promulgated by the center, cannot look into all these offenses as a investigating agency of first instance. So all these aspects, once you try and bring to the knowledge of your client, some of them actually gather that kind of courage. Okay, fine, now it's a plausible argument, we can take our chances. But at times, the pressure is so mounting, and it's always, most of the times the clients don't consult just one lawyer. There are too many brains being brought in, and everyone has a different perspective. I mean, I'm sure if a client is given to Pallavi, me, and Dr. Kumar, perhaps we may give different advices because we've brought up a certain way. We have a different style of practice, and all may be right in our own spheres. That's the whole idea of being an individual. I mean, learning from. I mean, I've had my experiences. I've learned the hard way. You've lost matters which you thought you would have won, and Pallavi might have won matters which she thought she must have lost. So I mean, that's how this how your practice eventually develops, and that's how you become a lawyer. So when a client consults more than one people and more than one person and different advice is given, that also somehow it dilutes the whole whatever intent you may have to safeguard the client. And as a result, if you're arrested or if your attached properties are attached, then it's always difficult to somehow getting the attachment done. Like Pallavi just said, the reasons to believe, and I completely agree with her. I have never seen reasons of belief in my practice. They are not given to us. It's reason to believe which believes in which exists in the figment of imagination of the deputy director or assistant director, whoever the guy is who is father. But it's his own creation. I mean, it could very well be nothing at all, but he just recalls two line, and a process of law which has its own importance, because eventually once you're taking away my property, it has to be done by a procedure established by law, and the procedure that's established by law has to be fair and reasonable. It can't be arbitrary. It can't be based on the whims and caprices of a guy who's somehow passed some exam, is now become some assistant director. I mean, don't take that is that emotional again, because I've actually I've seen it. I've seen these guys operate in a manner in which you somehow feel you're beyond you're above the rule of law. I mean, no court will look into it. The court will not second guess their investigative powers and all of that. So that's where that's where my kind of practice comes in, and that's where I've learned. When I see this, what do you call this? This insolence on part of the authorities, on part of these investigating agencies. That's where it irks me also. I said, okay, fine, we have you learned law, you try and you want the constitutional rights to be upheld, and when you see them being flouted, and that too with impunity, so of course you take it. I mean, at least I take it. I can't speak for everyone else. I take
I'm
it a
sure
bit,
it
a
hits a
tad bit
nerve.
personally.
I'm sure
Yeah,
it hits a nerve, Sharik. So thank you
yeah.
so much on highlighting the aspects that you mentioned on, the fear psychosis. I think that's what gets to people every time someone is summoned by anything to do with the law enforcement. The very reason we have this discussion is just to tell them that there are various ways this can be handled. The kind of things that you need to look into were mentioned by Dr. Kumar, Pallavi, and Sharik. So I hope the discussion was helpful to people. Before I close the discussion, I would just like to do another round of last comments from everybody, starting with Dr. Kumar. Dr. Kumar, there was a question I had in mind about plea bargaining. Seems the case that in the other jurisdictions in the Western countries, these offences are treated a lot differently. The conviction rates are higher. What is missing in the system, and one point from you on that?
Yeah, so plea bargaining, in fact, Ashima was introduced in the Indian system as well in the amendments to the Criminal Procedure Code in 2000. We have a section 265B, and it has its very specific limitations on the scope of plea bargaining, and the accused can make a request for plea bargaining, can move an application to a layman who is probably lot many non-lawyers who may be possibly watching this program. कोई भी ऑफेंस होता है तो उसको 3 बकेट में हम रख सकते हैं. एक कंपाउंडेबल, दूसरे वो जो पॉसिबली प्ली बार्गेनिंग के स्कोप में आते हैं, और तीसरे जो बहुत ही स्ट्रिंजेंट है जिसमें अप्लाई नहीं होता है. Why plea bargaining has failed in India is primarily because the way our entire judicial delivery system has been working so far has not been very conducive to encouraging plea bargaining in India. So the outlook of the prosecutor, the DAs in the American system, as we keep hearing, the outlook of the prosecution is quite different in the Indian setup, and for various reasons. I mean, of course, Sharik was mentioning it again very strongly. I just want to say that all these folks are from amongst us. They're all one of us. Just that when they go and occupy that chair, the trappings of that position is such, the way the system works in governance in India. In fact, transparency is possibly lowest in the list of priorities, and therefore writing anything elaborately that can make the entire proceedings transparent and accountable is something which is not on top of the priority. And that is the continuous tussle between the governance from the government side, the law enforcement agency side, and the judicial oversight. And every time a judicial oversight comes is essentially to clear up this, vagueness. So that's going to be there. We have to live with that. And coming back to plea bargaining, yeah, I think unless our entire judicial delivery system, especially on the criminal side, becomes a lot more transparent, the prosecution is made a lot more accountable, purely out of the conduct, not just the academic accountability in terms of code of conduct and etc. In terms of transparency, unless they are made accountable, plea bargaining is something that is not encouraged, because there are various factors which play out, various stakeholders whose interests clash, a lot of which cannot be discussed in a forum like this. But of course, transparency will make it conducive to discuss everything and iron out all those issues and make the prosecution accountable, so that they can encourage and give the right importance to an accused's rights to plea bargain.
Absolutely. Thank you, Dr. Kumar. Transparency is the need of the hour to even allow all rights to function. Pallavi, over to you for your closing comments.
No, I think there's now very little to say. We've already spoken so much, and Dr. Kumar has just sort of summed up everything. But yes, my only take is that I think everywhere, and specifically with these acts, when it comes to the implementation part of it, for all of us, like Sharik just said, that if there is the first instance, you look at jurisdiction and you try to challenge it. I completely agree with it. The fact that we sort of try and look at where all we can try and get as much legal right as possible through the court route, and that I completely agree with. But I from if it was supposed to be utopian world, and it was supposed to be the most perfect world, I would have appreciated if the court's interference would have reduced, because what is happening is that a stay comes in. There are matters where stay has come in like some 3 years back. There is not much that has happened in 3 years time frame, and what is happening is one party is actually enjoying the stay, the other party is really not, is completely affected by it. And at the end of the day, what are we seeing? That there is no light at the end of the tunnel, because there is no logical conclusion that is happening. And there are so many such matters, specifically as far as PMLA is concerned, smaller issues everywhere, and these are getting stuck. So yeah, in a perfect world, I would have wanted that all of these I'm sure as lawyers, our work would have reduced considerably, especially the litigating lawyers like us, whose bread and butter it happens to be. But it would have ironed out quite a bit of challenges that we come across. And the problem is that every single matter has more or less the same problems which are coming in, and we are approaching courts, and there is, so it's all of these matters are only getting tacked together, and no adjudication is happening. So I see that that kind of judicial intervention, somewhere it has to be managed, or maybe time bound in that
Some
sense.
method to the madness going on. So, Sharik,
Right.
over to you for your closing remarks, please.
No, I think we had a very illuminating discussion today, and if I could just sum it up, I mean, it's important that we have these kind of discussions in which we try to cater to the people who are eventually the recipients of this whatever little knowledge we may have of what we share and what comes out of these discussions. And at the end of the day, it's important that everyone who's afflicted or affected by these investigations must be well cognizant of their rights. They have to get, like Dr. Kumar pointed out the first time when he spoke, that you have to have a lawyer on board. I mean, most of the times most companies are penny wise and pound foolish. You let it slide. You say, okay, fine, nothing will happen. We'll see if you've done nothing wrong, and we are a very ethical company, and but when push comes to shove, you realize that it's opened a kind of worms that you never thought were there. There were skeletons in the closet which you thought didn't were there, but they actually were there. They were lying there for so many years, but you chose not to take expert opinion. You chose not to bring a lawyer on board. You thought that I'll do it myself. We have even at times the in-house legal counsel. I mean, all of them are very competent, but once you're in the field, once you're in the court of law, once you're on your legs arguing a matter, the ins and outs of how this the system works. It's always better to have expert opinion, have the right kind of people on your board who want to advise you of your rights and tell you what strategies are to be put in place. And Dr. Kumar pointed out that strategy, I 100% agree with him in these cases, and especially once you have a well-oiled machinery after you. I mean, if whether it's political or non-political or whatever it is, or some kind of vendetta, uh, you have to have a strategy in place. Okay, fine. If A does not work, this is B. I challenge jurisdiction, I fail, then I this, then anticipatory gone, then okay, fine, I'm B. Then how do I pursue that? And so all of that has to be kept in mind once you are faced with these problems. And expert opinion is very, very important, very, very important. I mean, if anyone is listening right now, you ought to have, even if it's a innocuous summon given in an ancillary matter in which you're not involved, you feel that I'm barely involved in it, but it's always it does. Stitch in time always saves nine. You have to get the right people on board, strategize, and let the you have to trust with the industry experts. I mean, you have to trust with them. You have to somehow, because till the time that does not happen, till the time you're always second guessing your attorney's opinion, your lawyer's opinion. It always messes the whole strategy up. Which, and I've seen cases suffer on that account. You give an advice and you feel okay, fine. Maybe he's saying because he wants to, the monetary aspect of it. There's so many other aspects. Clients have different perspectives in their mind, but it's important that you take the right kind of advice and always be prepared when it comes to these situations. Know your rights, and more importantly than knowing your rights, you should always know how to enforce your rights, because the enforcement is more important than just knowing your rights. So it's the enforcement where people like Dr. Kumar and Pallavi come in. We have to, helping the client enforce their rights. I mean, it's one thing for the right to exist on a book, entirely different thing for the law for the right to eventually culminate into some kind of protection being afforded to your client. So that's very important. That's where I feel experts should come in, and of course the courts have to play their part. Like I told, we have to have, it's a long way ahead.
Yeah.
Many of these sections have to be looked into. So I hope
Thank,
we soon evolve this jurisprudence.
thank you, Sharik. Thank you so much. So,
Thank you so
in
much.
common parlance, do not self-medicate. Please do not Google various things. Go to the experts. Allow them to take your matters in hand. Do not fear. There are ways to come out of some of these draconian laws. So I hope this discussion was useful to all of those who joined us today, and to common people, and non-legal minds, to legal practitioners, whoever has joined us. Thank you so much. If you have any more questions, please write to me at ashram@businessworld.in. We will take those questions to our experts. And experts, thank you so much for joining us today with these lovely, wonderful advices. And I'm sure they're going to be most useful to a lot of people. Thank you so much.
Thank
Thank
you,
you.
Ashima.
Thank you
Thank you,
so
Dr.
much.
Kumar. Thank you,
Very,
Pallavi.
very well hosted. Thank you. Bye.
Thank you,
Thank you.
thank you,
Thank you.
Dr. Kumar.
Bye-bye.
Thank you, Sharik. Thank you, Pallavi. Thank you so much.